So, hello everybody. Today we will be talking about labor standards, conditions of employment, salaries, and wages. So, let's first define what labor standard is. So, labor standard is the minimum requirements prescribed by existing laws, rules, and regulations as the terms and conditions of employment relating to wages, hours of work, cost of living allowance, and other monetary welfare benefits, including occupational safety and health standards. It also refers to that part of labor law which prescribes the minimum terms and conditions of employment which the employer is required to grant to its employees. Now let's talk about the basic duties of workers and employers. First is to perform entirely and conscientiously whatever work has been voluntarily and equitably agreed upon. Second, workers are not to be treated as slaves. Justice demands that the dignity of human personality be respected in them. Third, it is the duty of employers to see that the worker is free for adequate periods to attend to his religious obligations. And lastly, and the most important thing, to give every worker what is justly due him. Now let's proceed to the coverage of labor standards. So labor standards are only applicable to employees in all establishments and undertakings, whether for profit or not, but not to government employees, which are under the civil service law, managerial employees, field personnel, members of the family of the employer who are dependent on him for support, and workers who are paid by results. Those standards apply only if there exists employer-employee relationship between the parties. The recognition of the existence of employer-employee relationship is not dependent upon the agreement of the parties, but depends upon the fact of each case. In this sense, the existence of an employer-employee relationship is a question of fact. All rights and benefit granted to workers under the labor code shall apply alike to all workers, whether agricultural or non-agricultural, in the private sector only. Now let's talk about the conditions of employment. We will going to talk about first hours of work, second weekly rest period, holiday premiums, and lastly service incentive leave. Now let's talk about hours of work. So what is the normal hours of work? The normal hours of work of any employee shall not exceed to 8 hours a day. So why is it 8 hours? The 8-hour labor law was enacted not only to safeguard the health and welfare of the laborer or employee, but in a way to minimize unemployment by forcing employers in cases where more than 8 hours operation is necessary to utilize different shifts of laborers or employees working only for 8 hours each. How about those who only have part-time work? Considering the purpose of the law as mentioned above, it is not prohibited to have normal hours of work of less than 8 hours a day. What the law regulates is work hours exceeding 8. It prescribes a maximum but not a minimum. The law does not say that normal hours of work is or should be 8 hours, but that it shall not exceed 8. Therefore, part-time work or a day's work of less than 8 hours is not prohibited. Now let's talk about the principles that determines the hours of work. So the following general principles shall govern in determining whether the time spent by an employee is considered hours of work for purpose of this rule. First, all hours are hours of work which the employee is required to give to his employer regardless of whether or not such hours are spent in productive labor or involve physical or mental exertion. Second, an employee need not leave the premises of the workplace in order that his rest period shall not be counted. It being enough that he stops working, may rest completely, and may leave his workplace to go elsewhere, whether within or outside the premises of his workplace. Third, if the work performed was necessary or it benefited the employer, or the employee could not abandon his work at the end of his normal working hours because he had no replacement, all time spent for such work shall be considered as hours work if the work was with the knowledge of his employer or immediate supervisor. And lastly, the time during which an employee is inactive by reason of interruptions in his work beyond his control shall be considered time either if the imminence of the resumption of work requires the employee's presence at the place of work, or if the interval is too brief to be utilized effectively, and gainfully in the employee's own interest. Now let's proceed with the night shift differential. Night shift differential is equivalent to 10% of his regular wage. So every employee shall be paid a night shift differential of not less than 10%, again, of his regular wage for each hour of work performed between 10 o'clock in the evening and 6 o'clock in the morning. Night shift differential is applied most especially in the BPO industry, those working as call center agents. Now let's talk about overtime work, night differential, and overtime pay. So overtime work may be performed beyond 8 hours a day provided that the employee is paid for the overtime work and additional compensation equivalent to his regular wage plus at least 25% thereof. Work performed beyond 8 hours on a holiday or rest day shall be paid an additional compensation equivalent to the rate of the first 8 hours on a holiday or rest day plus at least 30% thereof. So let's talk about night differential and overtime pay. When the turn of duty of a laborer falls at nighttime between 10 p.m. and 6 a.m., the receipt of overtime pay will not preclude the right to night differential pay. The latter is payment for work done during the night, while the other is payment for the excess of the regular 8-hour work. Now, let's talk about the overtime pay rates computation. So first, for work in excess of 8 hours performed on ordinary working day plus 25% of the hourly rate. Second, for work in excess of 8 hours performed on a scheduled rest day or a special day plus 30% of the hourly rate. For work in excess of 8 hours performed on a regular holiday plus 30% of the hourly rate. And lastly, for work in excess of 8 hours performed on a regular holiday which falls on a scheduled rest day, again, plus 30% of the hourly rate. Now let's proceed with the weekly rest periods. So it is very important that within a week, an employee could experience a rest day. So what are the rights to weekly rest day? First is rest day, of course, is the period of inactivity of not less than 24 consecutive hours an employee after rendering service for a week. Week of labor, ordinary number of 6 labor days. The employer shall determine and schedule the weekly rest day of his employees subject to collective bargaining agreement and to such rules and regulations as the Secretary of Labor, Secretary Sylvester Bello may provide. However, the employer shall respect the preference of employees as to their weekly rest day when such preference is based on religious grounds. So why is rest day important? The purpose of granting a rest day is to promote the health, well-being, and happiness of the working class and is determined by the employee and the employer. That doesn't mean rest day is only Sundays. It could be Monday, it could be Tuesday, depending upon the employee and the employer. So now let's proceed. If you may ask, when can an employer require work on a rest day? So the employer may not require the employees to work on a rest day except disaster, calamity, urgent repairs, abnormal pressure of work, prevention of perishable goods, nature of work, favorable weather condition, exigencies of service, and the reason for this exemption is to prevent loss of life and property. Next question. May an employee validly refuse to render emergency work in rest day under the circumstances in the exception? The answer is no. You cannot validly refuse. You can be dismissed on the grounds of insubordination or willful disobedience of lawful order of the employer. So you cannot, in short. Now let's talk about holidays. So holidays, being days of rest and cessation from work, laborers are given the opportunity to satisfy their mental, moral, and spiritual needs. A laborer is deprived of that opportunity to satisfy those needs when he is compelled to work during holidays. And it is that deprivation which the law seeks to compensate in requiring the employer to give additional compensation for service rendered by their laborer during those days. So let's talk about holiday premiums. On any holiday, Work and or classes are suspended, and as a rule, where there is no work, there is no pay, but a holiday may be one of the two kinds. First, it may be a special no work holiday, of which at present there are three in a year. If a daily paid employee does not work on a special no work holiday, he gets no pay. If he works, he gets his daily basic rate plus 30%. Second, the holiday may be regular, sorry, of which at present there are 12 in a year. A daily paid or monthly paid employee, even if he does not work on a regular holiday, gets 100% of his usual pay. But if he does work on that day, he gets 200%. So some of the list of regular holidays include New Year's Day, Monday, Thursday, Good Friday, Eid al-Fitr, Araw ng Kagitingan, and so on. So you can check it online. Now let's talk about every laborer's right to holiday pay. So every worker shall be paid his regular daily wage during regular holidays except in retail and service establishments regularly employing less than 10 workers. Second, the employer may require an employee to work on any holiday, but such employee shall be paid a compensation equivalent to twice his regular rate. Sorry. And lastly, as used in this article, holiday includes New Year's Day, as I've mentioned, Monday, Thursday, Good Friday, the 13th of November, the 12th, 5th of December, and the days designated by law for holding general elections. Now let's proceed with the purpose of a holiday pay. So obviously, it is to prevent diminution of the monthly income of the workers on account of work interruptions declared by the state. In other words, although the worker is forced by law to take a rest, he is not deprived of what he should earn. So that's the purpose of a holiday pay. So there are special non-working days and the other special working days. But first, let us talk about special non-working days. The no work, no pay principle applies during special days and on such other special days as may be proclaimed by the President or by the Congress. Hence, workers who are not required or permitted to work on special days are not entitled to any compensation. This, however, is without prejudice to any voluntary practice or provision in the collective bargaining agreement providing for payment of wages and other benefits for days declared as special days, even if unworked. Exception, work performed on special days merits additional compensation of at least 30% of the basic pay or a total of 130%. Where the employee works on special day falling on his rest day, she shall be entitled to an additional compensation of at least 50% of his her basic wage or a total of 150%. So special working days. Let's proceed with the special working days. The special working days. So for those work performed on a declared special work day, an employee is entitled only to her daily wage rate. No premium pay, again, no premium pay is required since work performed on said day is considered work on an ordinary work day. So examples of this special working day includes the February 25, the EDSA Revolution anniversary. It is a working day but no class days in school. Now, let's proceed with the right to service incentive leave. Every covered employee who has rendered at least 1 year of a service shall be entitled to a yearly service incentive leave of 5 days with pay. Leave with pay means an employee gets paid despite absence of work. So the phrase 1 year of service means service within 12 months, whether continuous or broken. Reckoned from the date the employee started working. The period includes authorized absences, unworked weekly rest days, and paid regular holidays. If through individual or collective bargaining, company practice or policy, the period of working days is less than 12 months, said period shall be considered as 1 year for the purpose of determining the entitlement to the service incentive leave. Now, let's talk about separation pay. So what is a separation pay? It is the amount given to an employee who has been terminated from service for authorized causes, which could be either of the two, business closure or disease contracted by employee that could be prejudicial to their health as well as the health of their coworkers. How much is the separation pay, if you may ask? The amount given to the employee depends on the specific authorized costs for their termination, which could be any of the following. First is installation of labor, saving devices or redundancy, equivalent of at least 1 month pay or 1 month for every year of service, whichever is higher. Second, retrenchment, closure, or cessation of business, equivalent of at least 1 month pay or 1/2 month pay for every year of service, whichever is higher. Third, incurable diseases, equivalent of at least 1 month pay or 1/2 month pay for every year of service, whichever is greater. Now let's proceed with the special laws that every laborer and every employer should know. First is the paternity and maternity leave. Republic Act Number 8187, which took effect on July 5, 1996, grants paternity leave of 7 days with full pay to all married male employees in the private and public sectors. Paternity leave is available only for the first 4 deliveries of the legitimate spouse with whom the husband is living. Delivery includes childbirth, miscarriage, or abortion. The purpose of paternity leave is to enable the husband to lend support to his wife during the period of recovery and/or in the nursing of the newly born child. Maternity leave benefit is granted under the Social Security law in relation to Article 131 of the Labor Code. This will give every woman 105 days, regardless whether normal delivery or cesarean, an additional 15 days if you are a solo parent, and 60 days if you had miscarriage or emergency termination or abortion. Now let's talk about the parental solo parent leave. Additional to the list of paid leaves granted by law is the parental leave, known also as the Solo Parents Leave, because it is given to solo parents by the Solo Parents Welfare Act of 2000 and the Republic Act Number 8972, which took effect on November 28, 2000. The rules and regulations implementing Republic Act Number 8972 state in Section 18 that the 7-day parental leave shall be non-cumulative. The parental leave should be noted is in addition to the legally mandated leaves, namely the service incentive leave, the SSS sick leave, the SSS maternity leave, and the paternity leave under RA number 8187. Next. There are also two more special laws that we should know. First is the 2 months leave under the Magna Carta of Women, RA Republic Act Number 9710. A woman employee having rendered continuous aggregate employment service of at least 6 months for the last 12 months shall be entitled to a special leave benefit of 2 months with full pay based on her gross monthly compensation following surgery caused by gynecological disorders. And there is also the violence against women and children. Victims under this RA shall be entitled to take a paid leave of absence up to 10 days in addition to other paid leaves under the Labor Code and Civil Service rules and regulations, extendable when the necessity arises as specified in the protection order. So those are the special leaves that we should consider or we should know. So let's now talk about salaries and wages. So salaries and wages, we might think that they are the same, but actually they are different. Wages and salary differ from each other in a sense that, but first let's talk about their similarities. So salaries and wages both refer to a reward or recompense for service performed. But when we talk about wages, it's compensation for manual labor, skilled or unskilled, paid at state times and measured by the day, week, month, or season. It also indicates considerable pay for lower and less responsible character of employment, and it is exempted from attachment or execution, while salary denotes a higher grade of employment or a superior grade of service and implies a position in office. It is suggestive of a higher and more important service and is not exempted from any attachment or execution. So wage, in short, is a remunerations of earnings. Consider wages if paid in consideration of the labor being performed, the results of or finished work. So before we talk about the payment of wages, I would just want to clarify things. Salary distinguished from gratuity. Salary is different from a gratuity. A gratuity is something given freely or without recompense, a gift, something voluntarily given in return for a favor or service, a bounty, or a tip. So there's this what we call fair day's wage for fair day's labor. Continues to govern the relation between labor and capital and remains a basic factor in determining employees' wages. If there is no work performed by the employee, there can be no wage or pay unless the laborer was able, willing, and ready to work by but what was prevented by management or was illegally locked out, suspended, or dismissed. And the next principle is equal pay for equal work. Employees working in the Philippines, if they are performing similar functions and responsibilities under similar working conditions, should be paid under the principle of equal pay for equal work. So now let's proceed with the payment of wages. There are three that we have to discuss: the forms of payment, the time of payment, and then the place of payment. Now let's talk about the forms of payment. So the forms of payment, so take note of this. No employer shall pay the wages of an employee by means of promissory notes, vouchers, coupons, tokens, tickets, cheats, or any object done than legal tender, even when expressly requested by the employee. So the time of payment, wages shall be paid at least once every 2 weeks or twice a month at intervals not exceeding 16 days. No employer shall make payment with less frequency than once a month. Payment of wages shall be made at or near the place of undertaking, except as otherwise provided by such regulations as the Secretary of Labor and the Employment may prescribe. Now let's proceed with the minimum wages, regional minimum wages. So the minimum wage rates for agricultural and non-agricultural employees and workers, every region is different, okay? So there are differing regional minimum wage depending on the region you are living. So statutory minimum wage is the lowest wage rate fixed by law. An employer can pay his workers compensation which is less than such minimum rate is considered an underpayment that violates the law. So this is the purpose of the law, the regional minimum wage, assure decent living conditions of the workers, the basis of minimum wage not exceeding 8 hours a day. The methods employed in fixing the minimum wage includes floor wage method and salary ceiling method. Minimum wage varies from region to region, as I've mentioned, and these are the 10 factors to be considered in fixing the minimum wage. First is demand for living wages. Second, wage adjustment vis-a-vis consumer price index. Third, cost of living and changes or increase therein. Fourth, the needs of worker and their families, the needs in those industries to invest in the countryside, improvements in the standard of living, prevailing wages level, fair return of capital invested and capital to pay the workers, effect on employment, generation and family income, and in the equitable distribution of income and wealth along the imperative of economic and social development. So a person's need increases, his means increase. This is true not only as the food but as to everything else: education, clothing, entertainment, and others. The law guarantees the laborer a fair and just wage. The minimum wage must be fair and just. So here in Cagayan de Oro City, the minimum wage for non-agricultural is 365 pesos and for agricultural is 353 pesos. Now let's proceed with the salient features of the labor code. So the labor standard and labor relations are all under the labor code of the Philippines. So these are the salient features of the labor code. First, it reorients labor laws towards development and employment. It institutionalizes the NLRC, National Labor Relations Commission, to facilitate the speedy settlement of labor disputes. Third, it establishes a new system of workmen's compensation. Next, it establishes a system for employment of overseas workers and optimizes national benefit therefrom in the form of dollar remittances or improve skills and technology for our people. It institutionalizes voluntary arbitration as the mode of settling labor disputes. And with these, labor standards clarify and codify business owners' obligations to their employees and determine employment practices to help protect employees and employers while ensuring that neither is subject to unfair treatment or exploitation. The increase workers' bargaining power relative to their employers. Labor standards are first and foremost about the development of people as human beings. Work is part of everyone's daily life and is crucial to a person's dignity, well-being, and development. Economic development should include the creation of jobs and working conditions in which people can work in freedom, safety, and dignity. In short, economic development is not undertaken for its own sake, but to improve the lives of human beings. Labor standards are there to ensure that it remains focused on improving the life and dignity of men and women. So these are the reasons for affording protection to labor. So protection, so you can just read it. So these are the reasons why all laborers, all workers, all employees should be protected by the labor code. Now let's proceed with the limitations. So it is very important for us to know the limitations of the labor code and the labor law. First, protection to labor cannot be used as a pretext to defeat the rights and prerogative of an employer. Thus, the validity of the dismissal of an employee found guilty of violating rules designed for the safety of the employees themselves should be upheld because it protects labor and at the same time gives the employer its due. Next, protection to labor cannot be used as an excuse to distribute charities. Can we go back? Charities at the expense of an employer. Courts cannot render judgment on the basis of sympathies and inclinations and consequently distribute charities at the expense of the employer because our constitutional government assures the latter against deprivation of property except in accordance with the statutes and supplementary equitable principles. And lastly, protection to labor is not available where both parties have violated the law because in such a case, neither party is entitled to protection. So that ends my presentation regarding labor standards and I hope you've got something from it. Thank you so much for listening.